Good day, Advocate Dodson.
Good afternoon, Chief Justice.
Are you well?
I'm well, thank you, and how are you?
Good, good. Thank you. It's good to see you. It's been a while. Uh, okay. Oh, firstly, apologies for keeping you waiting now. We can be an unruly bunch as you would have experienced previously. It's not your first rodeo here. You were born in not far from here in Swaziland.
In Eswatini, yes.
Yeah. But you are a South African.
I am.
You are South African.
I'm indeed a South African, yes. Yes.
You are a holder of 4 legal qualifications.
Yes.
What are they?
BCom, LLB,
Cum laude.
cum laude, LLM, and a diploma in tax law.
All right. Where did you obtain each of these qualifications?
So my first two were at University of KwaZulu-Natal, Pietermaritzburg. The LLM was at Cambridge University in the United Kingdom, and the tax diploma was at the University of Cape Town.
All right. Your career didn't start at the bar. You started out as an attorney. Did your articles in 1985 and managed to rise very quickly, I see, in that law firm to head of public interest law, then public interest law department, then later director, partner. How long were you at this law firm, Malinix Incorporated?
I started articles there at the beginning of 1985, and I stayed there until I was appointed to the Land Claims Court in 1995, minus a year spent studying overseas.
And from there, you joined the bench at the Land Claims Court.
Indeed, it was a 5-year
5 years.
fixed-term appointment, yes.
How did you find that experience?
I beg your pardon?
How did you find that experience, judicial experience?
It was an extraordinary experience. I was appointed quite young.
Yeah.
I was 35 years old at the time, and it wasn't as though I was fitting into a well-established track that one might have with an appointment to the High Court, for example. It was a brand new court. We had to do everything. We had to find premises. We had to start libraries. We had to draft rules. We had to get a judgment writing style done. And then we had to hear cases that were very novel and under a brand new set of statutes. But I think I took to it like a duck to water. I really enjoyed my time there. The only downside, if I can call it that, at the time, there were the circumstances relating to land claims. I was appointed for a 5-year period in anticipation of all land claims being completed within 5 years, but that unfortunately didn't happen.
Is that why you left to do other things?
It was in part, yes. I was a little bit frustrated at the extent to which we weren't dealing with land claims, which seemed to me to be the most pressing item and the reason for my appointment. It was the end of my term. I was a bit worried about what the direction of the court was going to be, and I was young, and I felt that there were things that I could do in practice.
Yeah, but then your next area of interest was not far removed from what you had been doing at the Land Claims Court, I would imagine, is UN Housing and Property Claims Commission. What kind of work did you do there?
So that was also an adjudicative body set up by the United Nations to deal with the massive property dispossessions that came partially from the discriminatory regime that was applied by President Milosevic against Albanians, which led to people losing property rights. And then there was a whole range of loss of property rights arising out of the armed conflict. And we had to try to, we did successfully set up a process for people to be able to claim restoration of their property rights and a return, to try and promote a return of the rule of law to the property sector in Kosovo. So yes, it was related to obviously what I'd done in South Africa, but we applied different methods. I had some forewarning from what had happened in South Africa about the need to apply different methods to the processing of claims to try and get them done quickly. And we managed to get the job done. We dealt with 30,000 claims in 7 years.
Right. Your stint at the Legal Resources Center as its Director of Litigation, Constitutional Litigation Unit between 2004 and 2006 falls smack bang within your time in that UN engagement. How did that work? How were you at both places at the same time?
The way it worked was this: my initial engagement there for the UN was for a 6-month period, starting from August 2020 when I finished on the Land Claims Court, and then after that we would have claims prepared for us for decision making, and we would go for a week every second month to process and adjudicate the claims. So that gave me time to establish a career also at the bar at the same time.
Right. And in 2001, you had made the decision to join the bar.
Yes.
Okay. And practiced as a junior until 2011. So says your CV, until you took silk in 2011.
That's correct. September 2011, Chief Justice.
Okay. And how does your practice? What does it look like? What kind of work do you do? Do you have an area of specialty, or you take everything that comes through your door?
I can't say I do everything, but I do a fairly wide range of work. Obviously, my predominant areas of work have been in public law and constitutional law, but I have also done work in the areas of labor law. I do quite a lot of work in the personal injury field, mostly representing, in fact, entirely representing the state in those cases. I have, over the years, developed a reasonable amount of commercial work, but it's not the main part of my practice. And then, as time has gone by, I've done a couple of different areas. I've done a small bit of matrimonial work, and a few things like that. Yes.
Okay. I see from your questionnaire that once upon a time you were a member of the African National Congress. Those ties are no longer existing,
Yes.
according to this information. All right.
Yes, I was a member of the Salt River branch of the ANC, and I resigned when I was appointed to the Land Claims Court.
All right. And it is mentioned somewhere that you were once court-martialed. Would you want to tell us a little bit about that during a touchy period in our history?
Yes.
Yeah.
Yes,
refusing
as
to
disclosed,
do something.
I don't mind talking about it. I have a military criminal record. I was ordered during a military camp to do armed patrols of the townships around the south of Durban, and that would have required me to act completely against my conscience, against my moral perspectives, and against my political perspectives, and I refused to do it. It in fact happened twice. On the one army camp, they accommodated my refusal and they made me stand as a guard somewhere. And then on the second one, they weren't willing to accommodate me, and they said, if you continue your stance, we're going to order you, and if you don't do it, we're going to court-martial you. And that is what happened. So I said, I'm not willing to bend. And I was then court-martialed in the Natal Command, as it was called, in Durban.
Well, you have had an opportunity to act at the Constitutional Court. When was this, and how long was your stint or stints there?
I acted for 2 terms. The first was in the last term of 2023, and the second was in the first term of 2024.
And you wrote judgments during that stint which have since been delivered.
Yes,
How many?
I scribed, I think I scribed 3 judgments, and I wrote a dissenting judgment.
And you would have penned judgments during your time in the land claims court as well.
Yes, yes, indeed. And there's a list of those attached to my CV where they have been reported.
Yeah.
Yes.
All right. And in the middle of everything else, you've managed to write articles on legal issues, published articles.
Yes, I have written a few published articles, and they've tended mostly to focus on my area of expertise, which is one of my areas of expertise, which is in the area of land reform, obviously arising from my experience both on the land claims court and in Kosovo.
Yeah. You have mentioned that you once had health issues which has since resolved.
Yes, I had a form of leukemia. It had no consequential symptoms. It was discovered by chance, and I've had chemotherapy, and the result of the chemotherapy was completely successful.
And you managed to lead a healthy, active life.
And I managed to lead a healthy, active life. Yes, I try and do a couple of bicycle races each year. I also try not to fall off the bicycle, which is also not good for one's health. But yes, I do lead an active life. Thank you.
I raise this for the large part because of your age. You are 65 this year.
Yes.
How long does that leave you to serve on the bench if you are appointed?
It gives me just short of 10 years. And
another 10 years.
Yes, and that's the combination of Section 176(1) of the Constitution, read with Section 4(2) of the Judges' Remuneration and Conditions of Employment Act.
All right. Okay, I will leave things here for now and hand over to the commissioners to put questions to you.
Thank you, Chief Justice.
Starting with Judge President Lalezi.
Thank you, Chief Justice, and good day, Advocate Dodson.
Good day, Judge President.
Yes, just a quick one. Given your practice in the Constitutional Court, where you appeared and having acted there, is there any special skill that you would say is lacking, that you would have identified that we need to build on at the Constitutional Court?
Sorry, I didn't hear the last part of your sentence. Any special skill
Yes.
that is lacking that?
On that bench, that you would say it needs some attention?
I would not say that there is any lack of skill at the Constitutional Court. Having worked there, I worked together with an extraordinary group of permanent colleagues there who were deeply impressive, quite apart from the fact that they were extremely welcoming and wonderful colleagues to work with. Rather, what I would say is that what is lacking is resources. I think that the Constitutional Court was unfairly allocated a massive expansion of their jurisdiction when they were given a general jurisdiction on non-constitutional issues, with absolutely no increase, it seems to me, in the resources that were made available to them to deal with that additional surge of work, which has most certainly come. And there I believe, while I was there, I was able to play something of a role. I became involved in discussions about what might be done in that regard. I wrote a memorandum at the request of the other judges, giving some ideas about how the workload there may be able to be addressed through a constitutional amendment. And in fact, as part of that process, just to try and assist in discussions, I prepared a draft amendment to the Constitution that might cater for panel decision-making, similar to what takes place in the Supreme Court of Appeal, where applications for leave to appeal are dealt with by a panel of 2 judges, or if they disagree, a panel of 3 judges. Something which I think could make an enormous difference to the workload of the Constitutional Court.
You say the panel will work well for the apex court, which is the court that's got the last say, where you reduce it only to a few judges to decide an issue.
Sorry, I'm really battling to hear you, Judge President. If you wouldn't mind repeating the question.
Okay, sorry. You said you support the idea that there should be panels,
Yes.
like the SCA. But isn't the difference that the Constitutional Court is the apex court, and you'll be reducing decisions to only a few judges, whereas every judge of that court is expected to have a say on any decision as the law as it stands?
Yes, no, that I agree with you. That certainly is, in terms of Section 167(2), that certainly is the law as it stands. But unfortunately, there has been a surge, I think, as a result of that expansion of their jurisdiction. There's been a surge in applications for leave to appeal and applications for reconsideration. And some mechanism is going to have to be found to deal with that. While I was serving on the court, Chief Justice Zondo, on a trial basis, brought in 2 retired justices of the court to assist with applications for leave to appeal. But for various reasons, that wasn't followed through and wasn't found to be an optimal solution. But some solution does need to be found to assist in that process. For example, if one looks at the Supreme Court of Canada, they have an entire branch of permanent career lawyers within the Supreme Court that provide ongoing assistance to judges with dealing with things like applications for leave to appeal, obviously preparing memoranda and that kind of thing. And there needs to be something that has to be done to assist the apex court as far as that's concerned.
I see. Would you agree that the development and quality of jurisprudence does not lie solely at the apex court? The other courts have got a role to play, and strengthening those courts would go a long way to address even the problem that you have identified.
I would absolutely agree with that, Judge President, 100%.
Yes. And one has noted that it's not every case that goes to the apex court. You might have bad decisions, especially of those who cannot afford to take matters on appeal, having to comply with bad decisions which remain unchallenged.
Indeed. And as you point out, for many litigants, it's a luxury to be able to go all the way through the court system up to the apex court. And that's why the jurisprudence at high court level is so exceptionally important.
Yeah. Given your enviable CV and experience, I would have loved to have seen you maybe attempting to make yourself available starting at the High Court, and maybe also improve the jurisprudence at the SCA level. What's your view? Or is it with you, it has to be at the Concord?
Thank you for the compliment in relation to my
Yes.
to my CV. I appreciate that. I have followed a route towards the Constitutional Court that is recognized in terms of Section 174(5) of the Constitution. I have certainly acted fairly frequently in the High Court. I have also seen my time during practice as an opportunity to use my position as counsel to try to also there bring about aspects of transformation. I've tended to focus on cases that make a difference. And I think that in that role, I have been helpful to the high courts. All of those cases have to make their way up through the court system. So, for example, I've litigated quite extensively around the issue of how you deal with compensation for medical negligence claims, and have put a lot of work into presenting cases to the High Court there to give the judges there the opportunity to consider the evidence and arguments we present and to take those forward. So, yes, I started off as a judge in the Land Claims Court. It was a court of equal status to the High Court. I left for the reasons that I left. I've then had a spell in practice. The nature of my practice in the cases I have done, I think, means that I can be of assistance to the Constitutional Court. My experience when I acted there was confirmatory of that, and that is the reason that I followed the route that I have done and the slightly unusual career path that I have done.
Yes. Thank you, CJ.
Thank you, Judge President.
Commissioner Marumachai?
Thank you very much, Chief Justice. Good afternoon, Advocate.
Good afternoon, Commissioner.
I have two questions for you. The first question is in relation to Section 167, subsection 6 of the Constitution, direct access. It appears to me that that particular provision is quite clear. The circumstances that can lead to that court attaining direct access to a matter are quite clear. But in practice, it does not seem as if the Constitutional Court has provided clear guidelines as to when a matter will be ripe for it to be heard by that court on a direct access route. I'm not really sure, what is your view in relation to the jurisprudence surrounding Section 167?
I mean, the criteria that it ultimately always comes back to is whether it's in the interests of justice to allow direct access. And my sense is that that's going to be a very fact-driven inquiry as to whether in a particular circumstances something is in the interests of justice. And I think that may lead to a perception of unpredictability about it. But I think there are some principles that are established there. And perhaps the most important one is the principle that's been well established by the Constitutional Court, that their preference is to hear the views of other courts rather than litigants approaching them directly. Obviously, there are cases where the urgency of the circumstances prevent that. But speaking as a practitioner and speaking as somebody who has acted there, I think that it would be something that, as a practitioner, I would always advise a client to be very cautious about. One accepts also from having practiced there that there's a huge workload. One accepts also from having acted there that it's not a court that's designed to deal with urgent applications, because at least 8 of the judges have to participate in the decision making. It's going to be difficult. So I think, yes, potential applicants do need to accept that their chances are limited of being able to get direct access. The court is going to be slow to accept direct access cases. And I think, with respect, rightly so from the court's perspective.
Thank you very much. My second question is in relation to a case that dealt with the intersection between labor law and competition law, where the court had to consider whether the retrenchment of workers violated conditions attached to a merger approval. That is Coca-Cola Beverages versus Competition Commission. Do you remember that case?
Yes, it's one of the ones that I described.
My sense was there was a need to strike a balance between the expansion and sustainability of corporations in an open market and the need to protect employment. And that case traveled from the tribunal, where the tribunal used the so-called but-for test, the causation test. and then it went to the CAC, which developed a test that one can describe as some nexus sort of test. And when it eventually came to the Constitutional Court, it appears to me that you advocated for what can be described as a true reason test, which was, it appears, might have been crafted somehow by the tribunal in some ways. Now, there has been some criticism that the test that the Constitutional Court has adopted here potentially destroyed the protection given by the Competition Act to employees likely to be retrenched for reasons related to mergers, and to also allow firms to avoid merger protections merely by indicating that there are other reasons for retrenchment, and that the merger played a marginal role in the retrenchment. Based on what I've just said, one, do you think the criticism is fair? Secondly, is there a scope to really use the test that has been advocated for by the CIC? Because there are people who are saying that perhaps that is the test that seems to be protecting employment more than the one that is adopted by the Constitution, by the Constitutional Court.
I obviously reread the judgment in preparation for this hearing, and would also, as with any judgment, read it with an open mind and one that is open to criticism. But I think that if one looks both at the content of the agreements that were reached with the trade unions, in that case, in relation to the conditions and the way that they were worded, particularly using the words "as a result of," and if one looks at the statute and applies statutory interpretation principles to it, I think there's a difficulty with a standard that simply is as low, as it were, as some nexus, because it contemplates the possibility that, yes, the retrenchments were not as a result of the merger, but there is some nexus. And I think that would lead to the potential for injustices. The legislation is clear, and I think that the scope is still certainly there for anybody in a future case, provided they're able to prove the necessary causal links as far as merger and retrenchment are concerned, to be able to prevent retrenchments which are truly retrenchments that are as a result of the merger.
Thank you very much, CJ.
Commissioner Ngugai-Tobe, followed by Minister.
I suppose I could waive my right to the minister, given
You're wasting
her
time.
proximity to power.
Thank you very much, CJ, and good afternoon, Advocate Judge. Is it Mickey? I must make it.
Good afternoon, Minister. Yes,
Dodson.
advocate at this stage.
Advocate Dodson. Thanks a lot. You've done a lot of work around what I would call issues that deal with, or you have been advancing socioeconomic rights in communities, especially the poor and the vulnerable, looking at the work that you have done in NHI land claims and others, and also the work that you've done on class action, especially in the mining space. Do you think that in the manner that our current court rules, and also in the manner that our courts are structured, are conducive enough to be able to assist, especially dealing with class action for communities and in contributing to access to justice?
My short answer is no. There's a lot that has been done, but there isn't nearly enough that has been done as far as access to justice by all South Africans who want to make use of the court system is concerned. The reason for that is that our system is based on an adversarial system. An adversarial system works well when you have parties on each side that have legal representation, number one, and number two, that have legal representation that is of more or less equal skill and resources and so on. And unfortunately, there are many times where that is not the case. The worst case scenario being when a person is completely unrepresented against somebody who is indeed represented. Of course, there are many things that have been done to address that, and we must acknowledge what has been done since 1994. For example, during my time as a lawyer before being appointed to the Land Claims Court, the legal aid system was hopelessly inadequate. There is a lot of work that has been done to improve the legal aid system under the guidance of some of our leading judges as well. And I think we now have a system where, from a criminal point of view, I think legal aid has done exceptionally well in ensuring that people have the possibility of being legally represented in a criminal trial. Where legal aid hasn't yet come up to scratch is in the area of human rights law and civil law. And there it's a real resources problem. Legal aid needs more funding. We also have an exceptionally vibrant NGO law clinic culture in South Africa, and one has to take one's hat off to the work that they have done in advancing representation of people in South Africa. And extraordinary achievements that they've done. One must also acknowledge the work of the drafters of the Legal Practice Act, who did a great job in recognizing law clinics, creating a proper space for them in the regulatory setup for the legal profession, and also giving them special privileges in terms of the recovery of costs. So I think that has gone a long way in terms of helping people. And Minister, finally, as you pointed out, the introduction by the Constitution of the class action mechanism does provide a very important mechanism for extending justice. In the silicosis litigation, for example, we were able to extend justice to people who'd worked as miners in South Africa but came from countries outside of South Africa's borders. So that does present opportunities. But I come back to my original answer. Sorry, the answer was long. No, I agree with you. There's not adequate access to justice.
And just to follow on that, thanks a lot. And what do you think we should be able to do? Because if we acknowledge that definitely there are challenges, and in terms of what our forebear envisioned in the right to access to justice and for all of us to be equal, but to have equal access to justice, what are the areas you think that you should be paying attention to? But also, you're coming to the Constitutional Court, should you be considered? What role and what input would you make to ensure that such communities that you're talking about would be able to have this right that we talk about, which is fundamental in our Constitution?
In addressing it, obviously, legal aid needs more money. That's the first and a very clear thing. Another mechanism that we had available to us on the Land Claims Court, and that has been carried over into the Land Court Act, is a provision that says that the court may, in its discretion, act inquisitorially. And when I was on the Land Claims Court, I and other judges were able to use that position when we perceived that there was an inequality of arms between the different parties that might result in an injustice, to see if we could find ways of ensuring that an injustice didn't result. And I think that provision could be extended to other courts. It could be introduced into the rules of court, and I think that perhaps also with an element of training, judicial training, around limited possibilities for inquisitorial intervention, a significant difference could be made. As far as the Constitutional Court is concerned, my experience when I was there is that the Constitutional Court is quite spoilt in the sense that when there was a situation where somebody wasn't represented or there were problems in that regard, there were a range of organizations that were willing to step in and assist, including Pabasa, AFT, the Bar Council, and I was impressed at how readily advocates would make themselves available and attorneys would make themselves available at short notice to come and assist and present argument on behalf of parties at the Constitutional Court.
Thank you. Thank you.
Thank you, Chief Justice. Advocate Dodson, I just have two questions. I mean, the first one, I suppose, because you are a land specialist, is to ask you whether Section 25 of the Constitution is capable of being interpreted to include a requirement that there should be a right to property equality.
To property equality?
Yes. Or to land equality.
Well, as I read Section 25, that is ultimately its driving force is to strive to achieve land equality.
Yes.
And I think its beauty, in a way, is it doesn't just say that it doesn't just say that there's a right to property, for example. It goes on to give us very specific mechanisms to strive to achieve land equality.
So there is a constitutional right to land equality. That's your starting point.
Yes, I would say so. As interpreted through the redistributive security tenure and restitutionary components of Section 25.
Yes. Now, and at the moment, in the context where we have land injustice and land inequality, we are probably in breach of that section. The government is in breach of that section.
I would be slow as somebody who is a candidate for sitting on a court when
yes,
an argument
course,
like that might come before it.
But I mean, I suppose
to declare the government in breach. And let me also say, in fairness to the state, bearing in mind, in my practice, I act for all sides. I've acted mostly for communities and claimants, but I also act quite substantially for the state, particularly the Commission on Restitution of Land Rights. And I've also, on occasion, acted for property owners as well. I would be slow to simply say that the government was in breach, and I think one would have to, before coming to any conclusion, look at things a lot more carefully and closely. And it's in the kind of specifics where I think you would get answers. So, for example, I was involved in the Lamosa litigation and the Speaker of Parliament litigation, which looked at new claims and their impact on old claims. So it seems to me it's a kind of question that only develops answers in specific contexts. So in that particular context, yes, you had a situation where old claimants, as we call them, people who claimed before 1998, were confronted with not being able to get land justice, many of them because they're old, and it really remains a very big problem. So a solution was found, government was there found to be in breach, and a solution was found.
Yes, no, I perfectly appreciate that you don't want to commit yourself to the question of breach, but you can commit yourself to the question of principle. But then the second issue that arises from the first answer, which is there is a right to land equality. Is there a right to property equality?
I mean, what's difficult about that is that that's a completely novel area as to what is property. I know, for example, in your judgment in Sibanyoni, you pointed out very correctly and forcefully that cattle constitute property and a very, very valuable and important part of property. But I'm not sure that one could simply at this stage say that there's a right to equality of property. The reality is we live in a country that has inherited a particular economic system. We live in a country that also comes from an era when there was very aggressive efforts at disadvantaging the majority of South Africans, which have left them in a lasting unequal position. But we didn't have a complete revolution when democracy came in. It was a negotiated solution, and that was based on its own choices, policy choices, and has had its own consequences. It's an argument I'd like to leave open for somebody to come and argue were I to be appointed as a judge.
All right, okay. You'll also leave that question open. All right, fine, no problem. Then the second question, the real second question, is around the answer you gave on the mechanisms of the Constitutional Court and why there are delays. I'm not sure if there are delays. I think many judgments are given on time. There are probably one or two that delay. But nevertheless, the real issue I want to explore with you is whether you've done some research with comparable courts. I was looking yesterday in preparation for this interview at the US Supreme Court. They have, for what they call a writ of certiorari, a rule of 4. They get 10,000 applications every year. They hear about 80, but every judge reads every application. Of course, through clerks, I mean, not necessarily personally, you put your eyes over the piece of paper, but through systems in place. But the rule is that every judge must read every application, and if 4 of them want it set down, it will be set down. And once it's set down, if 5 of them agree, that will be the outcome of the court. I don't think the court receives 10,000 applications, the Constitutional Court. I don't know how many cases it has per annum. I'm not sure if it's 70 or 80, which is the same as the American Supreme Court. So somehow you have a system there that is capable of managing large volumes of work because it's also a court of general jurisdiction. And so there's something else that perhaps still needs to be accounted for to explain the delays or to explain the structural inefficiency. And the question is, what is it? Because it does not seem to be the volumes only, something else that we are still yet to point our fingers at. And what do you think that may be?
Sorry, I didn't hear the last part. What do I think?
What do you think that may be the distinction between why the US Supreme Court is able to read 10,000 applications, certify about 80 of them for hearing, and dispose of them quickly? And our Constitutional Court, which does not have a comparable volume.
Your question started with whether I've done research. The only research that I have done was a little bit of reading on how the United States Supreme Court controls their docket and how that came about. But if you read about what happened is a statute was passed. I can't remember which year it was. I think in the last century, early in the last century, a statute was passed which gave the court specifically the power to control its docket. So expressly to exercise the discretion to limit possibly even justifiable cases from coming before the court to manage its caseload. And if you look at the complaints that came from the judges before that statute was passed, it has a resonance with what I was hearing and seeing when I was acting in the Constitutional Court. The judges in the Constitutional Court work exceptionally hard. They work exceptionally long hours, and there is no shortage of industry on their part to try and get through what they get through. But to me, it seems that one needs to sit down and analyze the problem. And and I'm sure that there are ways in which one can work out mechanisms for resolving, getting through the large volumes of applications for leave to appeal. But the reality is that the applications for leave to appeal are taking up, as I saw it, time that should really belong to thinking about and preparing judgments. And yes, I think that when the court needs an opportunity to sit back, analyze where it's going wrong, analyze what can be achieved through a constitutional amendment, and analyze what can be achieved through an increase in person power. When we spoke, while I was there was a visit from the Supreme Court of Canada, and they've got this echelon called the Law Branch, which, as I said, was a group of professional lawyers who have full-time careers there. And I think they play a huge role in getting these applications for leave to appeal ready for consideration by the judges. But they do operate in panels. They're the highest court in the land, and they do operate in panels, both panels in terms of, as I understood it, applications for leave to appeal, but also panels in terms of the actual adjudication of cases. So you can have cases where I think it was 5 judges sit to hear a case and would be recognized as a quorum. And one of the thoughts that I had, I haven't taken it any way down the road, but maybe one could have a system where when the Constitutional Court acts under its constitutional jurisdiction, under that provision, even if only partly, one sticks to the en banc decision-making, the full bench decision-making requirement. But maybe for consideration is when one is dealing with its general jurisdiction, one allows, for example, for a 5-person panel. As I say, I haven't thought it through carefully, but I think there needs to be the opportunity for sitting back, reflecting, and seeing what can be done to manage that caseload.
Thank you, Chief Justice. Thank you, Mr. Dodson.
Just to add to what you said about Canada, I don't know about the US Supreme Court. It probably has the same systems, but most apex courts have sifting measures so that not all process that comes to the court has to have 11 minds of the justices bear, upon each and everyone, even the unmeritorious ones. And this constitutional court is in the process of trying to get a professional board of lawyers, similarly to other apex courts elsewhere, to assist it with these problems. So that's just one measure, and it will be interesting to hear other views from people such as yourselves, Advocate Dodson, on how we can resolve our issues. But I just want to endorse what you said, that justices in that court work extremely, extremely hard. We exchange emails at all sorts of hours on the daily for little or no pay, I may add.
It was really to deal with the concern raised by J.P. Tlalezi, that at the apex court, the litigants expect the benefit of having all of the eyes reading their petitions, but then that's not practical.
Yeah.
Yeah.
Okay, it's Commissioner Mangena.
Thank you, CJ. Good afternoon, Advocate Dodson.
Good afternoon, Commissioner.
Can't hear you, Commissioner.
Oh, I don't know what's happening with this. Is it better?
Yes.
Advocate Dodson, I've got one question, depending on the answer that comes. It may be two. A precedent is an incident of the rule of law. Precedent, stare decisis, right? Now, you are going to, if you are elevated, if you become successful, you'll be elevated to the Constitutional Court, which is the apex court in the country. Can the Constitutional Court depart from its own judgments? And if so, under what circumstances?
Yes, it can, but only where it finds that its previous decision was clearly wrong.
in the period that you have been there, and from your reading as well, have we had a situation wherein the Constitutional Court had departed from its own judgment?
Not while I was there, no.
Thank you, CJ.
Any further questions, President, followed by Commissioner Hassan?
Good afternoon, Mr. Dodson.
Good afternoon, President Monamela.
How are you?
I'm well, thank you, and how are you?
I'm well, thank you. My question relates to the provisions of Section 167, subsection 3 of the Constitution, and I confine it only to the general jurisdiction of the Constitutional Court. Now, that provision states that the Constitutional Court has jurisdiction to hear matters that raise an arguable point of law of general importance, which ought to be considered by that court. What, in your view, would be relevant factors for purposes of determining whether a matter raises arguable points of law of general public importance?
If I can just get a moment to have it open in front of me, if you'll just bear with me. But essentially, the court has laid down what its approach will be to the interpretation of that particular provision. And it's really determined with reference to the wording of the particular, the components of the wording of the particular section 167 3B2. So first of all, there's a requirement that leave to appeal must be granted, which immediately brings into play the requirements of interests of justice, prospects of success, amongst others. Then, on the grounds that the matter raises an arguable point of law, and that obviously is quite a well-established test that ties in with that ties in with the reasonable prospects of success criterion. Probably a pithy way of asking, are there reasonable prospects of success in this particular case? And then of general public importance, obviously that brings into play the criterion that the determination of the particular issue in respect of which jurisdiction is sought must extend beyond the interests of the immediate parties to the dispute and have a potentially broader impact for the rest of society.
Yes. So, sorry, if I may come in, just to qualify the question. Leaving aside prospects of success and confining yourself to to arguable points of law of general public importance, can you maybe give one or two examples of what you consider to be such a matter? In other words, a matter that raises important points of law of general public importance. One or two examples.
Yes, I think the example that immediately springs to mind is the judgment that I wrote in the Huntrex case, which related to a servitude to cultivate a garden on a neighbor's property. And that was a case where the respondent specifically said, this is not an issue that deserves the attention of this particular court. It's a fight between two neighbors and doesn't go beyond that. But once one looked at it a lot more carefully, it fell quite neatly within this particular category of jurisdiction, because it impacted not only on the immediate parties to the dispute, but if it was a predial servitude, it would carry on ad infinitum in respect of all future owners. It also emerged on the evidence that registrars of deeds were registering similar servitudes without having regard to whether or not they were indeed lawfully registrable. So yes, that I think would be for me the clearest example that I came across in my experience while acting there.
Yes, thank you, Chief Justice. The second question. So the question, it's actually a follow-up on your previous response, but I want to pose it having given you a preamble of what the Constitutional Court said in two matters. And the question that I'm going to ask thereafter is, under what circumstances should the Constitutional Court consider it not to be in the interest of justice to decide factual issues that pertain to the merits so as to correct the erroneous evaluation of facts by a lower court? And now, in one judgment, the Constitutional said the following, and I quote, "If it emerges from the record that the trial court misdirected itself on the facts or that it came to a wrong conclusion, the appellate court is duty-bound to overrule factual findings of the trial court so as to do justice to the case," unquote, meaning interest of justice. In the interest of justice, then they have to do that. And then in a second judgment, the Constitutional Court said the following: "The public interest will be best served by prompt resolution. Such resolution will help to correct the wrong decision before it has further consequences on one hand, and to avoid delay and inconvenience resulting from the failure of this court to hear the appeal on the other hand. The evidence is sufficient to enable this court to deal with and dispose of the matter without referring it back to the Supreme Court of Appeal for reconsideration. It goes without saying that the interests of justice require this court to entertain the matter, as remitting it to the Supreme Court of Appeal for reconsideration will give rise to considerable inconvenience, prejudice, and impede the attainment and administration of justice." And it went on to say, "It seems that in the circumstances of the case, we should not follow that route," in other words, the route of remitting, "but we should determine the appeal ourselves. This is because this court does entertain direct access appeals from the High Court in appropriate cases. The matter has dragged on for a long time, and if we remit it to the Supreme Court of Appeal, it is likely to end up back with us." It goes without saying that the interests of justice require this court to entertain this matter, as remitting it to the Supreme Court of Appeal for reconsideration will give rise to considerable inconvenience, prejudice, and impede the attainment of the administration of justice. And then they went on to say, "The matter has dragged on for a long time, and if we remit it to the Supreme Court of Appeal, it is likely to end up back with us again in any event. We have already heard full argument, and we should avoid having to hear the matter for the second time. The route I propose to follow will avoid a duplication of costs," unquote. I then pose this question: when will it not be in the interests of justice for the Constitutional Court to decide a matter where factual issues have been raised, but there was an erroneous evaluation of facts by a lower court? So remember, at first I said you must give examples of when it would be in the interest of justice to consider those aspects. And now the question is, when is it not in the interest of justice to deal with matters that are raised in a particular case that are considered to be raising important aspects, points of law of public importance that pertain to factual issues. I hope you understand the question. Thank you.
My understanding of the issue in relation to factual issues is essentially that has been laid down since S versus Bosak by the Constitutional Court, and that is to see factual disputes as issues that actually fall outside of its jurisdiction. As I recall, and I can't immediately think of the cases, there may have been exceptions made in particular circumstances, but the basic rule, and the rule that was applied while I was acting in that court, was that we do not have jurisdiction in respect of purely factual disputes. That, along with a related category, which is where there is a well-established rule or principle, and the lower court gets that rule or principle right in terms of its articulation, but doesn't correctly apply it to the facts, there too, the court will not assume jurisdiction in those cases. So it seems to me that unless there's a particularly unusual circumstance, that is the way that the Constitutional Court would deal with those factual matters. They would see them as jurisdictional, and they would decline jurisdiction in them. As I understand the other part of your question, it relates more to when will the court simply go ahead and decide the issue itself, or when will it remit to the Supreme Court of Appeal. And my sense is that the main criterion that would be applied in those circumstances is to ask, do we need the input of the Supreme Court of Appeal on this issue, having corrected whatever the Constitutional Court has corrected? Do we need the input of the Supreme Court of Appeal on this issue before we come to a final conclusion, if it were to be sent back to us again following the SCA's adjudication, or it might end at the SCA if there weren't any further appeals? And to give a particular example is that the Supreme Court of Appeal, they're the experts on the common law. So it seems to me that where there's a tricky issue pertaining to the determination of the common law, that might very well be an example of something that they will be inclined to remit to the Supreme Court of Appeal so that they get the benefit of their views, either by way of that presenting a final solution of the case in the SCA, or by way of, if it were to come back to them, they would then have the benefit of the SCA's expertise in that area.
Thank you very much, Mr. Dodson. Thank you, CJ.
Follow up?
Thank you, Chief Justice. Good afternoon, Advocate Dodson.
Good afternoon, Commissioner Pillay.
Just in relation to the question posed by President Molamela, how would the Constitutional Court's recent judgment in the Vodacom matter make a difference to your answer, where the court upheld an appeal based on the failure of the duty of proper consideration, and held that in limited instances where there's been a failure of justice, that would constitute a ground of appeal because it's a failure of Section 34, fair hearing right?
So, unfortunately, I read the judgment on the day that it was handed down, and I haven't looked at it since then. But my sense is that the reasoning, if my recollection is right, that the reasoning is related to the point that I was making in relation to hearing the views of the next court down in the hierarchy on the issue. And the concern that was expressed in the Vodacom case was that there was no clearly discernible path of reasoning in the judgment of the Supreme Court of Appeal. And that for that reason, in a sense, they hadn't actually used the opportunity when it was in front of them to give a clear legal answer to the issue. And my understanding is, for that reason, it was sent back for consideration by a differently constituted bench, so that the court could express itself with a clear path of reasoning that would allow either the matter to be resolved there on the basis of a clear path of reasoning, or come back potentially to the Constitutional Court, but in circumstances where the Constitutional Court could see more clearly with respect why the Supreme Court of Appeal had arrived at a particular conclusion.
Chief Justice, I have a second question. May I place it now and then I'm done? Thank you. Advocate Dodson, your application was made in June 2025. And in August, the judiciary adopted its sexual harassment policy. Just to check firstly that wouldn't in any way have deterred you from applying had the policy been adopted prior to you bringing the application.
Not at all. I've read the policy. It is an exceptionally well drafted, well thought out document, extremely impressive. It puts in place sensitive mechanisms for dealing with the issues. It hearkens to the rights in the Bill of Rights as a guiding criterion in the way that it is laid down. It creates a special office to deal with these issues. Extremely impressive document, and I would not just not have an objection, I would fully support it.
Now, Section 5.1 of the policy states that sexual harassment violates, amongst others, Articles 5 and 6 of the Judicial Code of Conduct. Article 5 refers to the duty to act honorably in a general sense, not confined to your judicial tasks. And that's reaffirmed by Article 6, which says that a judge must at all times, even in relation to extrajudicial conduct, comply with the law. Now, do you believe that the policy should apply to extrajudicial conduct?
Yes, absolutely. Absolutely. The reputation of, the starting point is the victim. No person should be the victim of sexual harassment in any circumstances, at court or away from a court by a judge. So I have no hesitation in endorsing that. And from the point of view also, secondarily to the victim's rights, the reputation of the judiciary. The reputation of the judiciary is done irreparable harm if somebody were to be involved in sexual harassment, even away from the court, as it were.
Thank you, Advocate. Thank you, Chief Justice.
Commissioner Hassan?
Thank you very much, Chief Justice. Advocate Dodson over here, thank you. I wanted to ask a question as one of the younger commissioners currently sitting on the JSC. Many young South Africans, they're sort of increasingly questioning whether the Constitution still works for them. And of course, this is born from a number of different socioeconomic issues. But from your vantage point, what must the Constitutional Court do differently to regain the trust of a disillusioned generation?
I'm not sure that I can accept the premise, which is that the Constitutional Court as an institution has lost the trust of the younger generation of South Africans. But I have three adult children, so that's my feed-in, as it were, perhaps to that generation. What I can certainly understand is a potential loss of faith in the Constitution itself because of the...
That's actually what I meant, in the actual Constitution and the delivery thereof. So you're not wrong in your first assertions.
That I can understand. The particularly the rights from Section 23 through to Section 28 are rights in the Bill of Rights that embraced a unique promise to South Africans. Yes, a number of those rights come with a built-in reality check in the form of progressive realization, but still they hold a promise. And if you drive through any informal settlement or something like that in South Africa, you can see starkly and in your face that we're still a good distance off realizing those rights. So yes, I can understand the loss of trust in the Constitution, and yes, it must automatically follow from that the courts, all of them, including the constitutional courts, must be mindful of that, and mindful of the need to keep faith in constitutional democracy and a society regulated on the basis of the rule of law. The best I think I can say is that those rights set a standard for adjudication which must be taken into account, and the concern you've raised must also be considered in that decision-making process.
I think just related to that, you've mentored quite a number of younger advocates. And so my next question, or sort of related to this on young people and youth, is what would that mentorship for your element look like inside the Constitutional Court, but more particularly, how can the court become an active incubator of diverse judicial talent as opposed to just a recipient of it?
I believe the court has done exceptionally well through its clerks program. It's been there for a long time. It takes place under a system of mentorship and supervision with 2 clerks allocated to each of the judges, and it presents an extraordinary opportunity for them to learn and grow through the process. I was blown away by the level of responsibility that is given to the clerks. I was blown away by the level of access that is given to the clerks to the decision-making process. Pretty much every email that you send in the course of deliberations copies in the clerks. So that was certainly something I didn't anticipate, but it's what is there. And I see the product of that approach on the part of the judges of the Constitutional Court in some of the attorneys and advocates that I work with in the course of my practice. It has produced and continues to produce the most exceptional and talented lawyers in this country. So yes, I think substantially through the clerks program, they're getting it right, but there's always more that you can do. And I don't know if having spent 2 terms there provides me with a sufficient basis to critique the court, but it has an open day in which there's an accountability to the public. And it also seems to me that if one is to accept that there could be an echelon of permanent career lawyers within the administration of the court to assist the judges, that would also provide exceptional opportunities for developing people in constitutional law.
Last question, CJ. You've chosen, advocate, to stay largely in practice and in public interest work. Why do you think it's important that the Apex Court also includes voices from outside the bench or this permanent sort of judicial seat? And what perspective do you believe that brings yourself in interpreting the Constitution in a very rapidly changing society?
So just to make sure I'm understanding your question correctly, you're talking about people who come something along the lines of the route that I've followed into the court and what they can bring to bear in the court's decision making.
So traditionally, people who apply for a position at the CC, of course, have been sitting judges for a very long time. So I'm interested in your perspective as somebody who's chosen to stay in practice in that way, dealing with public interest work. What benefits, what disadvantages, et cetera, et cetera.
Thank you. I believe that Number one, the Constitution is designed to accept people with other career paths through the provisions of Section 174(5), which allows for up to 7 of the judges not to be serving judges at the time that they're appointed. And I think that that isn't a fossil from days gone by. I think that there's a reason behind it. And that is that in your apex court deciding such important issues, you want ranges of diverse experience influencing your decision-making process. And I think that the reality is if you accept people who might come from academia, for example, perhaps also having been given the opportunity to act as judges as well to round off their academic experience, if they've perhaps acted in the high courts, you can bring important influences to bear. Also, from the point of view of practice, I don't think should be seen as something that is a zero or a negative in terms of what your credits, as it were, are for an appointment to the apex court. I think it is helpful for the court to have somebody there who's argued through all of the different levels of court. And there are interesting parallels and differences in the kind of mental processes that go on. For example, in the preparation of heads of argument and the presentation of argument. Preparing heads of argument follows a very similar intellectual process to preparing a judgment. And I think is important experience for the purposes of drafting judgments. Once heads of argument are there to persuade the court to decide in your client's favor, when you write a judgment, what you're doing is seeking to explain, give it another word, persuade, the party that you're deciding in favor of, that the correct decision has been arrived at. So there are similar trends. There is also sometimes, and I say it a little bit tongue in cheek, a propensity on the part of judges who've been judges for a very long time to forget how tough it is out there arguing cases as counsel. And maybe having somebody who's been counsel more recently amongst you is something that brings a different perspective. But that's not obviously my main submission. My main submission is allowing people who followed a different path enriches the decision-making process of the apex court.
Commissioner Moimang?
Thank you, CJ. Good afternoon, Advocate Dodson.
Good afternoon.
Let me just build on the first question posed by Commissioner Hassan, but it will be also in relation to one of the judgments that you have raised in your questionnaire, Lamosa judgment.
Sorry, which judgment, Commissioner, if I may ask?
Lamosa judgment.
Lamosa judgment, yes.
Yes. The question posed by Commissioner Hassan in relation to the confidence of young people in the ability of Concord to dispense justice for all and the values essence right in the Constitution. In that judgment, the setting aside of restitution of Land Rights Amendment Act of 2014. In response to the question posed by Commissioner Ngukatobi on the property equality and the referral to the government being in breach of promotion of property equality. Don't you think that because the government, through that act, wanted to go further in relation to the Restitution of Land Rights Act of 1994 by reopening the land claims from 2014 to 2019 was an attempt on the part of government to breach the deficiencies in expediting land claims. And don't you think that those land claimants that lodged their claims between the 1st of July 2014 and July 2016 would then, in the face of that act being set aside, lose confidence in the ability of the Concord to promote justice for all, because the claims that they lodged were set aside because of the Concord judgment on Lamosa? Thank you.
Just, Commissioner, respectfully to start with the correction. The claims that were lodged were not set aside. They were recognized as having been validly lodged. And what the court did, though, is that they put them on ice. They said, we're going to hit the pause button, as the Commission must hit the pause button as far as those claims are concerned. And the reason that they did that is the terrible situation that we have in South Africa, where people who lodged their claims by the 31st of December 1998 were promised a right of restoration of their land. And tragically, the vast majority of those people are elderly people. The impact of intruding into the process, the 2014 now to 2016 claims, was to present the potential for still further delay. People have waited for close on 30 years to have their claims adjudicated. And I speak obviously in a partisan way because I was effectively representing those elderly claimants whose right to have their claims processed before they died was prejudiced by those new claims, as we called them. So I don't see that court judgment, if there's a proper understanding of what the court was trying to achieve, I don't see it as a basis for a loss of trust in the court. It was really an act to try and come to the assistance of realizing elderly people's constitutional rights, and to make sure that things were done in an appropriate sequence. They'd gone to the trouble of lodging their claims before the 31st of December 1998. They were elderly. They were entitled to be first in line. But the court didn't knock out the claims that had been lodged. No, it said the moment that the processing of the elderly claims has been completed, then processing can start. And there were also exception clauses in the order that the Constitutional Court formulated that said it is a particularly justifiable reason for somebody in that part category to come to court. You can approach the court and ask for relief.
Thank you, Advocate.
Thank you, Commissioner.
Thank you. No further questions. All right. We have reached the end of your interview, Advocate Dodson. Thank you very much for making yourself available and not giving up on us. Wishing you all the best.
Thank you, Chief Justice, and thank you to all of the commissioners for the hearing you gave me.